Good morning, everyone, and welcome to the July Mortgage Quality and Compliance Committee webinar. This is Susan Milazzo, CEO of the California MBA, and I'd like to welcome you to today's webinar presentation. Before I turn it over to our committee chair, I would like to give you a little information about a couple of events coming up for the California MBA in August. We have our CAMPAC golf tournament happening on Sunday, August 5th at the Rancho Bernardo Inn in San Diego. Fantastic course. We've done it there for a couple of years and a lot of fun. We do have still availability for some foursomes, so we'd love to have you come play golf with us. You can find that information on our website, or you can email me directly and I'd be happy to give you that information. We also have a Mortgage Technology and Servicing Conference coming up August 5th through the 7th in San Diego. Got some great technology products that we're going to be featuring there, doing some wonderful product demonstrations, as well as a very a great servicer panel that is going to be moderated by Caroline Reeves of Mortgage Contracting Services, and a keynote presentation from Sean Krause of Rocket Mortgage. So a great conference. We've got some great deals to participate if you are interested in doing that. And lastly, we have a free networking event coming up in San Francisco on August 14th at Blend, one of our member companies. So all of those information for all of those events are available on our website, cmba.com. So hopefully you can join us. With that, I'd like to turn it over to Monica McCarthy with Crosscheck Compliance, who is going to be moderating today's webinar. Monica?
Great. Thanks so much, Susan. Next up, we have our California legislative update with the CMBA's legislative advocate, Pat Zenzala.
Thank you. First, start with where things are in the legislature. Legislature, thankfully, is on summer recess. They're coming back August 6th, and they'll have their last few weeks sprint of passing legislation between the 6th and the end of the month. So I'm going to talk about three bills that I think are of interest to mortgage industry. First one is AB 375. This bill actually has already passed and been signed into law. It has an effective date of January 1st, 2020. Just going to very, very briefly talk about it because it is a very complicated bill. And if you want to hear more, by the way, I'll be speaking about it in much more detail at that technology and servicing conference that Susan just mentioned. So the essence of this bill is it's one of the broadest privacy protection bills that have passed in the country. I think it is the broadest as far as potential impact. And it allows consumers to essentially find out from a business that collects personal information on them, the specific pieces of personal information that the business has on them, who they've collected it from, who they're sharing the information or selling the information to, and also it allows for the consumer to ask for the business to stop selling or sharing the information, and they can also ask for the information to be deleted. So provides consumers with a great deal more control over their personal information. This bill was passed as an alternative to a privacy initiative that was going to be on the November ballot that was actually even more broad and had less provisions in it to allow business to operate. There are some exemptions in this privacy bill for use of information for business services. So this is still preferable to what would have been on the initiative, and if the initiative had passed, it would have been very problematic. SB 818 is a bill that deals with the California Homeowner Bill of Rights. This bill would reenact sections of the California Homeowner Bill of Rights that expired at the end of 2017. These are the provisions that apply to servicers that have had more than 175 foreclosures in California over the last 12-month period. And so this bill will reenact some of those provisions. The positive news is we were successful in getting language in the bill to actually help in compliance with the Homeowner Bill of Rights in general. One of the amendments creates essentially a 5 business day cutoff prior to the sale date of a foreclosed property, where if a customer wants to apply for a modification, they have to do it 5 business days or more prior to that sale date, or otherwise the application is considered incomplete. And then also there was some provision to help with a potential conflict between a Homeowner Bill of Rights outreach requirements prior to beginning the foreclosure process and the Federal Fair Debt Collection Practices Act, where a customer says, "Stop contacting me, regarding collection of a debt." And there's provisions in there that basically say if a customer contacts you in writing to stop contacting you, then you can still comply with or meet the requirements of the outreach prior to filing a notice of default. The final bill I want to mention is SB 1201. This deals with foreign language translation requirements. There are currently requirements in statute for the origination of a loan if you negotiate a mortgage primarily in one of 5 specified languages. This bill extends the requirements to modifications, and it keeps the same model as with originations, which is the Department of Business Oversight provides on their websites translated forms of the key terms, and a lender that decides they want to negotiate in one of these 5 languages can pull down the forms, put in the details of the key terms, and provide that to the customer per the statute, and there's a safe harbor if you use the DBO's forms. So those are the 3 bills that I wanted to briefly summarize, and the second 2 bills are in the legislative process. They have not passed yet.
Okay, great. Thank you so much, Pat. Next up, we have Michael Pfeiffer, who is the CMBA's General Counsel, to provide us with his legal update.
Thank you, Monica. Good morning, everybody. The case I wanted to talk about today is entitled McNair v. Maxwell and Morgan, PC. Maxwell and Morgan is a law firm, and so some of you are going to go, okay, it's time to shut off my brain. I'm not going to pay attention. But I want you to pay attention to what's going on in this case, because it can have significant implications for essentially a whole range of your business operations. Next slide. Basically, in this case, we're dealing with the Fair Debt Collection Practices Act, the Federal Fair Debt Collection Practices Act, and the issue that's raised is, when is foreclosure debt collection for purposes of the FDCPA? As you know, the FDCPA has a broad range of prohibitions on conduct, including some of the ones that Pat just mentioned about contacting borrowers and if they indicate that they don't want to be contacted. In this particular case, and there have been some cases in front of the Ninth Circuit on this issue, and I'll talk about one of those as we go through this. But in this particular case, the consumer had purchased this property in Arizona. As you recall, the Ninth Circuit covers a lot of the western states, and so it includes outside of California. But there, the property was purchased in Arizona, and there were a number of HOA assessments that the property was subject to. Basic standard situation where the assessments are payable in monthly installments, and there was a default. Under the provisions of the CC&Rs, the homeowner association had the right to collect the debt, as well as late fees and their attorney's fees. They could bring the action. They could bring an action, a lawsuit, or they could foreclose on basically a statutory lien that's created by the CC&Rs. The law firm in this particular instance represented the homeowners association and sued the plaintiff in state court for collection. And so they settled that, had a payment plan, but then the debtor defaulted on the payment plan, and they revived the state court action, and they got a default judgment. That's typically part of these settlement agreements, is a stipulation to a judgment. The law firm then represented the homeowner association in a new lawsuit against the plaintiff after another default. Remember, they're living in the house, the assessments continue, so there was another default, and so they filed a new lawsuit, settled that one with a payment plan and stipulated to judgment. this time stipulating that the homeowner association could sell the property if there was a default on this payment plan. Next slide. So, of course, there was a default, and so the law firm went to the court and requested, and the court granted what's called a writ of special execution. This is basically under Arizona law. It's equivalent to California's, roughly equivalent to California's judicial foreclosure statute. And the property was sold at a foreclosure sale. And the homeowner association received, as indicated, $11,600 in satisfaction of the debt, and then an award of attorney's fees and costs, which probably, I don't know that off the top of my head, but I think the attorney's fees were probably, significant addition to the $11,600. The plaintiff then sued in federal court, saying that everything that had gone on was a violation of the Fair Debt Collection Practices Act, and that the law firm had misrepresented the amount of the debt by seeking attorney's fees to which it was not entitled. And the trial court granted the homeowner association, granted the law firm a motion for summary judgment, basically saying, number one, that the law firm was not engaged in debt collection as defined in the FDCPA, and that the filing of this writ for foreclosure did not violate the FDCPA because the court had later approved the attorney's fees claimed in the writ. So they thought everything was fine. The borrower then appealed. Next slide. This went to the Ninth Circuit Court of Appeals, and they reversed the award on summary judgment, and basically said the trial court erred in saying that the foreclosure proceedings were not debt collection, and that they pointed out that under this U.S. Supreme Court case from 1995, which all of us in the legal profession are aware of, attorneys who regularly engage in consumer debt collection activity are debt collectors under the Act. That was controversial when it came out, but not a lot has been done with it. And recently, 2017, through a series of amicus efforts, from various organizations in our state, the Ninth Circuit had indicated in the case of Hovey Recon Trust Company that actions taken to facilitate a non-judicial foreclosure are not attempts to collect the debt, and therefore they're outside of the Fair Debt Collection Practices Act. Here, however, the Ninth Circuit said, this is different because the object of a non-judicial foreclosure sale is to retake and resell the security, not to collect money from the borrower, and that California does not allow for deficiency judgments following a non-judicial foreclosure, and that's why Ho was decided the way it was. But here, they were trying to collect the debt rising from their failure to pay the HOA fees, and there was an opportunity for a deficiency judgment, even though that wasn't necessary here because the property was enough to cover it. Next slide. They basically said that they rejected the argument that the state court had approved the attorney's fees, saying that the representation in the writ had accrued, that the fees were due pursuant to a stipulation, and that a motion had to be made to get the court's approval of the attorney's fees. It couldn't be concluded that they had done so simply by implication, that there had to be an official motion and official ruling on that, and therefore there was a misrepresentation. Now that all sounds kind of arcane, and you wonder, well, why are we talking about this case? The answer is for decades, maybe even centuries, there's been a common law privileged, recognized for actions taken in connection with litigation. It's called the litigation privilege. The notion being that if people are, in order to facilitate the adversarial process and the give and take of a litigation, that the attorneys have to be privileged to assert whatever arguments and to take whatever actions within the bounds of the law, of course, that will facilitate the presentation of their respective clients' positions. And so this litigation privilege has existed for a long, long time. It's been interpreted by hundreds of court decisions, and it is kind of, among the legal profession, it's considered kind of a sacrosanct thing. What this case does is it basically says, okay, it extends the decision back from 1995, saying that attorneys can be debt collectors, and it's saying even if you're acting in the course of a litigation proceeding, that you can be subject to the Fair Debt Collection Practices Act. I think that's going to have a chilling effect on a lot of things. For example, if the debtor says, don't contact me, how do you serve them with a summons and complaint? Those are just some of the issues that arise. So we haven't heard the end of this story. I don't know whether it's going to be appealed or not. I'm looking into that. But just wanted to make you aware of that, because if it stands and if it stays the way it is, it can significantly impact various members of our industry, because it does cover judicial foreclosure, not non-judicial foreclosure. But the key part is it invades that notion of the litigation privilege. So that's my presentation.
Great. Well, thank you so much, Michael. We appreciate that. Next up, we're going to move to our presentation, and I would like to introduce our speaker today, Jason Goldstein. He is the chairman of the Buchalter Law Firm's Mortgage Banking Group, and he specializes in real property-related litigation. He's located in their Irvine office. Jason defends lenders, brokers, and servicers on issues related to negligence, fraud, TILA, RESPA, California's Homeowner Bill of Rights, wrongful foreclosure, as well as lender-servicer liability matters. Jason also has expertise in prosecuting title insurance and escrow causes of action, misappropriation of trade secrets, judicial foreclosures, and general civil lit. He is a fellow of the American College of Mortgage Attorneys and is a member of their Title Insurance Committee. Jason is a frequent speaker at industry conferences, and when he's not busy working, he is a SoCal Elite AAU basketball coach. So with that, let me turn it over to Jason so that he can coach us on title and escrow best practices.
Thank you very much, Monica, and thank you all for listening in. I really appreciate the opportunity to discuss one of my favorite topics, title insurance and escrow. A lot of lenders think that title insurance and escrow are something that can just be put in the back room, and it's something that they don't really have to think about, that it's sort of formulaic and their instructions are fine. But I'm here to tell you that that is really not the case. Your instructions to the escrow agent and the title insurer are extremely important and deserve to be looked at, revised, and updated so that you provide yourself and potentially your assignees with the most protection possible. Obviously, the escrow, in my mind, is when the whole transaction is born. You brought the borrower, you found the borrower, lender's ready to fund. You obviously need title insurance in order to close the transaction and sell it on the secondary market, or in any event to protect your interest. So how do you use that process to provide you with the most protection? What I'm going to discuss with you today is stuff that I've actually learned in the trenches. I've been practicing solely in the area of mortgage lending for the last 16 years. I sue title insurance companies, I sue escrow companies. So lenders, you're going to get some great firsthand information. And if there's any title or escrow officers, you may feel a little uncomfortable, and I apologize for that. There's a lot of good title insurance companies and a lot of good escrow agents, but let's just begin. Okay. Who are the players in title insurance and escrow? Secured lenders and buyers and sellers of real property. Obviously, there's an escrow for the loan transaction, and to the extent you end up foreclosing on your collateral, you'll eventually need to sell that property. So there's going to be an escrow both in the origination of the loan and the sale of any property after a foreclosure sale. So what we're discussing here is important throughout the entire life of a loan and what may occur if there is a default in the loan. The first thing I want to point out is, what is an escrow? We've all participated in escrows, if not hundreds, if not thousands of times. But what is it really? This is going to focus on California law, but it's generally the same nationwide. California has definitions of what an escrow is in the Civil Code and the Financial Code. But there's kind of a simple definition that I use. An escrow is a situation when you provide a third party with documents or money and instructions to do something with it. Again, an escrow is that simple. If you provide a third party with documents or money and instructions on what to do, they are your escrow agent. Why is that important? One, once someone's your escrow agent, they're what's called a fiduciary. A fiduciary is someone who owes you the highest obligation you can under the law. That includes the duty to disclose, the duty not to conceal, and it provides you with a basis to bring certain claims in addition to your contract claims that you would have if you have appropriate escrow instructions. An escrow agent, as your fiduciary, is required to strictly comply with your instructions. That means if they deviate in any significant respect, you have claims against them. This is why you need to make sure your instructions are very clear and updated, as I'll discuss as we go further on. But in addition to the written instructions, instructions can also be oral or implied. So if you actually have a conversation with the escrow agent about something in particular, that may form the basis for an escrow instruction. Now we're going to go just to the beginning of what to do when there is a problem, and then we're going to go through what those problems might be on a high level and give you the background necessary to deal with them appropriately. The first issue is, if there is a problem or you suspect it's a problem, you should consider tendering a claim to your title insurer and your escrow agent. Normally, if some issue comes around that seems to affect title, people will generally tender a claim to their title insurer. But what happens in my experience is that they forget to look at their escrow instructions to see if they actually have an escrow claim in addition to a title claim. Why is that important to consider both? Because the title insurance policy contains about 4 separate provisions that provides a way for the title insurance company to provide you with less than the amount that is stated as your insurance. On your title insurance policy, there'll be the insured amount on the top, which is normally your loan amount. And then in the fine print towards the back, it says 4 ways the title insurance company can pay you less than that. However, your escrow agent does not have any sort of provision to that effect. You get to sue them for all damages proximately caused. This means your principal, your interest, any other damages you may have been caused by their negligence. Whereas under your title insurance policy, the most you're going to get on a contract claim is the policy limit. We're going to discuss endorsements to title insurance policies later, but please note there is an endorsement that can increase your insurance policy by 25%, 15 to 25%, and I'd recommend getting it with every policy you ever buy, because if there's a title insurance claim, there's going to be time that goes by between the tender and the time it's resolved, and if you don't have that cushion, you're going to lose money that you otherwise could recover. You should consider obtaining legal counsel. Title insurance, I always refer to as title insurers are like Vegas. They don't make money paying out. Title insurance companies, their primary expense is to pay for attorneys. And if they're going to have attorneys looking at your claim, you should have one to protect your interests. Again, just to repeat, tender your title insurer and your escrow agent. It's important not to lose the right to do it. If the title insurance company or escrow agent accepts your claim, you should consider having counsel monitor the handling of your claim. If you just let the title retained counsel defend you, they may take actions that benefit the insurance company and not yourself, so you still need to be diligent. It's always great to have someone else paying your attorney's fees, but you don't want that to be the insurer who's paying the attorney to do things to benefit the insurer and not yourself. And that goes along with trying to be diligent. All right, so here's the first problem that comes up in title insurance and escrow that I want to make sure that everyone understands, and that is, if you use, well, strike that. You need to make sure that you are using the title insurer as your escrow agent when you're doing these transactions. There are many what I'll call mom and pop or independent escrow companies throughout the United States, but they generally have very little insurance and they have very little bonding and very little assets. If you're doing loans in the amounts of hundreds of thousands of dollars or millions of dollars, you want to make sure that you have an escrow agent that has sufficient funds to be able to pay your claim. If you're doing $15,000 loans, then maybe you can use an independent escrow agent, but otherwise I'd recommend against it. Also, if you can have the escrow agent be affiliated with the title insurer, that will provide you with the most protection. I'm not giving a recommendation as to any particular title insurance company. This is just an example. But if your title insurer is going to be First American Title Insurance Company, your escrow agent should be First American Title Company. That's because both of these entities are related, and if there is an issue that comes down the line, the title insurer can't use the excuse of, well, maybe the escrow company knew about it, but I didn't, therefore you didn't disclose it to me, and therefore I'm going to deny your claim. If you do use an independent title company, or independent escrow company, instead of what I was recommending right there, and you deal with a situation where the borrower's signature is forged, you can expect a denial under the title policy based on exclusion from coverage 3A. I'll actually show you that provision later on, but exclusion from coverage 3A is the most used exclusion in the policy of title insurance to deny claims. Exclusion from coverage 3A basically denies claims if you, quote, created, suffered, assumed, or agreed to it. Conveniently, none of those terms are defined. However, rest assured, the title insurance company will construe them in ways the law does not want them to. There's also the issue of whether the borrower or the guarantor lack the required authority. You're making a loan to a corporation and you don't know, well, you make a loan to a corporation and later on the corporation says, oh, the person who signed did not have authority. If you use an independent escrow agent as opposed to one that was affiliated with the title insurer, you can expect to get that claim denied. Problem 2, using escrow instructions which are not adequate. I have seen over my career hundreds, if not thousands, of different lenders' escrow instructions, and actually probably more like hundreds, and many of them are not adequate. From the largest national banks to the smallest independent lenders, you cannot judge the quality of the escrow instructions by the size of the institution. And here are some issues that I want to point out that you should make sure are addressed. 1, your escrow instructions, which some people call lender instructions, should be jointly directed to both the escrow agent and the title insurer. The reason for that is you want to have one document, preferably, that has your instructions about recording the document and closing the escrow, as well as separate instructions on insurance. Many times I've seen instructions where it states something to the effect of, if you can provide me with a policy of insurance that insures me as a first lien, then you can close the escrow. In a situation like that, if you go to litigation, the escrow company will say, sure, I recorded you as a 31st, but the fact is, all you wanted was insurance that you were a first, and we gave it to you. Therefore, we complied. This is why you have to make sure that your escrow instructions specifically state you can only record my deed of trust if it will be recorded as a first priority lien. You need to make sure that there are separate instructions dealing with insurance, because if it goes into litigation, you're going to get the situation I just mentioned. We're going to look at it in more detail later. There's another exclusion from coverage, 3B. 3B basically says, let us know everything that you know about this particular loan and do it in writing that's not reflected in the public records. What does that tell you to do? It doesn't tell you anything specifically to do, that's for sure. Everyone on this call, I believe, would agree with this, that title insurance is the only policy of insurance you obtain without having to fill out an application for it. If you want to get car insurance, if you want to get medical insurance, if you want to get E&O, you're going to have to fill out an application. However, for title insurance, they don't do that. Why is that? Well, from my experience, they don't want to know anything on the front end. Title insurers do their underwriting on the back end when they're trying to deny your claim. And one thing to know about my analogy that title insurance is the only type of insurance that doesn't require an application, I should clarify, the only one that doesn't require a written application, because exclusion from coverage 3B is actually the secret undisclosed application for title insurance that no one complies with, because that's what requires you to submit information in writing before the loan is closed. So there are a few ways I've devised, along with my law partner, John Hosack, who wrote the first book on title insurance. There are provisions you can add, which provide that the title insurance company has the opportunity to look at your loan file in its entirety before the policy is closed. You can include a hyperlink in your instructions to your loan documents. Or 3, you can send the title insurer a disk with every document you have on it for them to look at it before they issue the policy. To the extent borrower privacy concerns are raised, you could easily have a disclosure that the borrower signs or an authorization which says, I authorize you to provide any of my documents to the title insurer. The reason for this is because title insurers, once the loan funds and there's an issue, then ask you for your entire file to review it. And if there's some document in there that happens to implicate a potential title issue that you did not disclose in writing before the policy was issued, that's not reflected in the public records, will then be used against you to deny your claim. Title insurers also sometimes will issue title insurance policies which do not reflect what is really in the public record and what they know is in the public record. Situations that happen sometimes with construction lending, sometimes in general lending, is that title insurers will take an indemnity from a third party in order to insure over an existing defect. Your instructions should include a provision that prohibits the use of indemnity or similar device to eliminate a matter as an exception to coverage in the title policy. I've had cases where title insurers have done that, where they have actually used an indemnity agreement to insure over a defect that my client would have wanted to know about, resulted in years of litigation to get rid of the defect. And at that point, the property became almost valueless, and the borrower obviously did not pay. So those are something you want to make sure are in your escrow instructions to prohibit the use of, because if there is one in the title policy, you then have a claim against them based on your escrow instruction. To the extent you're doing construction loans, you want to make sure that your instructions provide that there may have been the commencement of the work of improvement for the purpose of mechanics lien, because no one knows if some building supplies were dropped off the night before or whatnot. You want to have complied with your disclosure obligation and put the onus on the title insurer. Problem 3, notaries. Obviously, every deed of trust or mortgage requires that the borrower's signature be notarized. Please be wary of any notary public that is not employed or selected by the title insurer. That's because if the notary is not employed or selected by the title insurer or their affiliated escrow company, title insurers will use that as a basis to deny your claim because you will have selected the notary. The notary will have notarized someone's signature that wasn't who they purported to be, and therefore they'll claim that the title insurance company will contend that your claim is denied under coverage 3A based on your creating that particular title defect. For that reason, you never let an independent escrow agent select the notary. If you use an independent escrow agent, and maybe they have a lot of insurance, you confirm that this is, you'd rather, take the risk of some issue, at least have the title insurer select the notary. That will at least save you a couple of the issues you have with the independent escrow agent and put some liability on the title insurer. In California, a notary is only required to have a $15,000 bond. When I've had to file lawsuits against notaries and various people and title insurers, pretty much the notary's bond company will pony up the $15,000 bond because it's less than litigating. But when you're dealing with $1 million loan or hundreds of thousands of dollars in loan proceeds that are now unenforceable because of a forgery, the $15,000 doesn't cut it. So relying on the notary's bond is something that should not be done. I actually took the deposition of a former general counsel of a major title insurance company. And at that deposition under oath, he told me that, literally, quote, notaries are the title insurance industry's dirty little secret. They account for approximately 5 to 10% of all claims. So, hopefully you're not dealing with a lot of title or escrow claims, but when they do happen, there's a 5 to 10% chance it was caused by the use of a notary. And if you personally selected the notary was affiliated with your company or was affiliated with an independent escrow agent, there is unfortunately a good chance the title insurance company will deny your claim. We suggest that in your escrow instructions that you specifically require that the that the title insurer, that you specifically provide that the notary be selected by the title insurer, be employed by the title insurer, or be on their approved list. And obviously the notary's kind of the last stage of defense. They're supposed to get the identification of the borrower. There's an argument that if the notary sees that the borrower lacks capacity, perhaps it's an elder, that then that liability for determining capacity may be imputed to the lender when the lender is the one who chooses it. So please don't forget the issue with notaries. Please have the title insurer employ or select the notary. Lack of proper endorsements. This deals with the title insurance policy you're going to get. And what I want to share with you is that a title insurance policy in its purest initial form is like a house with a hole in a roof. A title insurance policy is specifically drafted like a house built with holes in the roof. Endorsements are like the patches you would put on a hole in your roof here on your title policy. What is an endorsement? An endorsement is an amendment or a modification of an existing policy of insurance. It's not a separate contract of insurance. Standing alone, it means nothing. But when you have the title insurance policy with the holes in the roof, and you get the proper endorsements to patch those holes in the roof, you're going to have a bunch more protection than you do under the standard policy, because the standard policy was never meant to be purchased without endorsements. I've done separate webinars solely on plugging the holes in your title and policy and dealing with 7 critical endorsements. If you go to my website in my bio, there's a whole list of prior slides that I've done on presentations if you have any interest. But just realize that there are more than 100 different endorsements, and determining which ones are best suited for your types of loans should be considered with great care, so that way you know you're getting the protection that you want. Endorsements generally don't cost that much, so an ounce of prevention, really will help you out. Just give you a couple examples of endorsements. One is for usury. Obviously, most lenders have exemptions for usury, but if you assign your loan and you go to another state, there sometimes can be issues. Subdivision Map Act, sometimes there's issues with that. That's an endorsement that I see routinely. If you're ever going to modify your loan, this is obviously one that would be obtained after the loan is closed. You should consider getting a modification endorsement. There's issues that can arise if you're in first and there are junior liens and you modify your first without getting the consent of the junior. If you don't have a modification endorsement, there's a chance you could have some liability to the junior and no protection under your current title policy without the endorsement. Sometimes if you make partial reconveyances of your lien, in situations where that may occur, there are endorsements you can get for that. If you're doing a construction loan, you can get certain endorsements for each disbursement. Access. This is a big one. In general, title insurance may provide for a right of access without this endorsement, but that doesn't mean you'd be able to get there by a road. Access could be by air, access could be by boat, access could be by tunnel, but you can get an access endorsement that says, we ensure that you have access to, 123 Jones Street via, the street name right in front of it. And this will ensure that you actually have access to the property through a way that is easily accessible. Okay, problem 5. Everyone reviews preliminary reports before they close a loan. However, there are limits to a preliminary report, and I want to make sure everyone here knows about it. First of all, you can't rely on a preliminary report. And the reason is it does not reflect the actual condition of title. It is an offer to insure and nothing more. Preliminary reports can be changed. Sometimes they don't tell you about it, but please be wary of that. In California, insurance code sections 12340.10 and 11 basically tell you that a preliminary report is something that you cannot rely on. It's merely an offer to insure, and if it's wrong, you have absolutely no claim regarding it. Years ago, I believe it was probably in pre-1983, there was something called abstractor's liability, where if the contents of a preliminary report were incorrect, you had a claim. Now, you no longer have a claim based on the preliminary report. I can't say how many times people have told me, well, I looked at the prelim and it said this. Well, please now be advised, if you didn't know already, whatever's in the preliminary report cannot be relied upon. When you get your title insurance policy, then you actually have something that can be relied on in a sense. The title insurance policy is what's called a contract of indemnity. If there ends up being something incorrect about it, the title insurer is supposed to do one of two things. One, pay you or indemnify you, or two, either defend you in a lawsuit or take action to remove the title defect. But no matter what, the title policy is still not a guarantee that title is as it's stated in there. There is a product that you can obtain. It's called an abstract of title, and that's the only document you can get which actually guarantees that the title is as reflected. When you actually do get the title insurance policy, it's my recommendation that as soon as you get it, you review it and you compare it with the preliminary report that you received to make sure that the policy accurately reflects what it is you thought you were getting. If you only look at it years later when an issue arises, you may have been able to avoid an issue earlier on by just making that comparison. Exclusion 3B. This was what I was telling you earlier, is the concealed application for insurance. And I want to let you know that there is a defense to Exclusion 3B. But in any event, here is the actual policy language regarding 3B, and it basically says that, if there's anything not known to the company, not recorded in the public records, but known to you and not disclosed in writing, you will have your claim denied. This puts the onus on you for anything that's not out in the public records. However, sometimes the insurer knows things that aren't in the public record. And although the insurers will not share this with you, the disclosure obligation, at least under California law, is a two-way street. In fact, Insurance Code 332, which I've quoted below, provides that each party to a contract of insurance shall communicate to the other in good faith what he knows. Therefore, while exclusion from 3B may say that the potential insured has to have a disclosure obligation, the law makes it two-sided. So if the insurer tries to deny a claim because you did not disclose something, but they really already knew it, you'll have a defense. And one of the things that I want to make you aware of, the reason I recommend sending the entire loan file to the title insurer, as well as, or to the alternative, offer to provide it to the title insurer, is because there could be a document in there upon which the insurer may later say, aha, you had knowledge of something that could create a title defect, or that there was a title defect, and you didn't disclose it to us as required by 3B. There's a case I cited at the bottom, Stewart Title versus Credit Suisse, in which a insurer claimed that a appraisal in the lender's file disclosed the potential for the recordation of a mechanic's lien and therefore denied the claim. That thing was litigated for quite a while and then ultimately settled, but the point is, what's in your file can be used against you. How do you structure your transaction to provide yourself with the most protection? Well, you also need to make sure that you understand the other exclusion, which is 3A. I discussed that a little bit earlier, but here's the actual language from the policy. And basically, it excludes coverage for any defects, liens, encumbrances, adverse claims, or, quote, other matters. Who knows what that can be? Whatever a claims attorney wants to use to deny your claim, that is created, suffered, assumed, or agreed to by the insured claimant. There is a case out of Louisiana where a court held that the existence in a credit report of a trade line that referred to a mortgage, even though that mortgage was not disclosed in the preliminary report, provided the basis for a title insurer to deny a claim based on exclusion 3A. So here's a situation where there was a preliminary report, it looked clean, and a policy was issued, and that policy was clean. However, deep within the bowels of the lender's file in a credit report, someone did not notice that there was a reference to a trade line for a mortgage, and it turns out that mortgage was actually recorded and that it just didn't show up on the prelim, and because of that, the lender was denied title insurance coverage. So please be wary. Your underwriting of the file may cause you to lose coverage, even though the title insurer never asks you for the file, doesn't want to see the file, at least until they actually have a claim. If you're doing construction loans, I don't know how many people on the call do it, so I'll be brief on this. if you're making disbursements when the borrower is in default and there are subordinate liens, that may be a situation where you can lose title insurance coverage. If you're making disbursements under a construction loan and you don't get an advance endorsement, you may possibly lose title insurance coverage, at least to the extent of the advance. Improper disbursements may cause a loss of coverage. There are situations in which a lender can stop making disbursements based on a borrower's default. However, in the two cases I just cited, when the lender stopped making payments due to the borrower's default, the contractors recorded mechanics liens, and these courts held that there was no coverage under the title insurance policies for mechanics liens, which is normally a covered risk. And in fact, in that B&B case, I believe the loan was about $60 million, and at the end of the day, they recovered $1 million, all because of Exclusion 3A and disbursements. As I mentioned earlier, when you deal with a title insurance policy, there are approximately four ways in which the title insurer can pay you less than what would otherwise be the maximum policy limit. However, the claims with your escrow agent are not so limited. And again, please remember that an escrow agent is someone who handles money or documents. They don't have to have escrow in their name. They can say First American Title Insurance Company, Lawyers Title Insurance Company. If you give them documents and instructions, they're your escrow agent. Normally, the title insurer records your deed of trust. So if you actually have a separate instruction to the title insurer to record your deed of trust as a first, they're your escrow agent. An escrow agent's your fiduciary. Your insurance company is likely not, which limits some of the claims you may have. Escrow agent has a duty to disclose information to you. The escrow agent is more favorable measure of damages. All right, sorry, this went a little slow on the screen. Please note that you need to promptly tender your claim. If you don't promptly tender your claim, the insurer may be able to deny it just on that basis. The time for an insured to respond to a complaint is shorter than the time in which a title insurer has to make a coverage decision. So normally, if you get served with a lawsuit and you need to make a title claim, try and get an extension from the opposing party so that you'll have time for the title insurer to make their decision. If you actually answer the complaint or demur on your own, the title insurance company will have a basis to delay. Make sure to allege escrow claims against your title insurer. They record documents. Realize that there are sometimes arbitration provisions in your documents and that you can seek to have those removed at the initial stages. You need to consider tolling agreements. If a title insurer accepts your tender of claim, that case may be going on for years. And if it goes on for 2, 3, 4 years, you may lose claims not only against the title insurer for bad faith, but you may lose the ability to sue your escrow agent. So consider a tolling agreement when you get there. Problem 11, the California Fair Claims Settlement Practices Regulation. These are the regulations that govern insurers in California, and it provides specific time frames within which they need to respond to your claim. So knowing these time frames can help you better deal with making sure not to respond to a complaint to get coverage, to avoid having the insurer delay. If you are lucky enough to have the insurer accept your defense, keep diligent on their litigation strategy. Is it delay or is it to help you? Be wary of who the insurer selects. Sometimes they have a series of attorneys that they hire that they use all the time. They may not have your best interest in mind, but instead the person who pays them. In that situation, sometimes there's litigation guidelines. I had a case where there were the title retained counsel couldn't even do legal research without the approval of the title insurer. Please note that if there's only one claim that's potentially covered, the insurance company is supposed to defend the entire claim, the entire complaint, So don't let them say, we'll defend one claim, you hire someone else. That's against the law, and that's the Buss case, the late, great Jerry Buss of the Los Angeles Lakers. The reason you got to monitor defense counsel is because sometimes they have secret communications with the insurer, and they're not to your benefit. Also, the insurer may not select the best experts for you, so please be diligent and a part of the process. In conclusion, please be aware of the limits of title insurance coverage. It's not going to just pay you the policy limits. There's multiple ways to provide you less. You need to try and make sure your escrow instructions are as strong as possible, because they can provide you with a better protection and more damages if things go south. Avoid a notary public that's not employed by the insurer or selected by the title insurer. That could be the linchpin of your claim. If you do your own disbursements, I don't think anyone really does, but be careful. And if you have a claim, please be assertive and vigilant. Don't let the title insurer take you for a ride. If anyone has any questions, I'd be happy to try and answer them, and I really appreciate your time listening to me speak on a subject that I love, and hopefully provided you with some insight you did not have.
Well, thank you so much, Jason. That was definitely very informative, a lot of information, and the good news is the slides will be available to folks on the CMBA website. Good to share those as well with others at your respective companies. We do have a few minutes available for questions. So if you do have a question for Jason, you can type the question in the dialog box, and we will try to answer some of those questions. In the meantime, I do have just a couple questions I wanted to ask you, Jason. It certainly sounds like you do sue the title companies and escrow companies frequently. What would you say is the most common or the most customary cause of action that you're asserting these days?
Generally, it's the standard tort and contract claims. It's negligence, breach of contract, negligent misrepresentation, and fraud. If the escrow agent misrepresents a fact, you have not only a contract claim, you also have a tort claim. So don't just rely on the claims in your escrow instructions. Also go for the tort causes of action when you have them.
Okay, interesting stuff. One of the other things you mentioned was you recommended that lenders be diligent in monitoring their claims, and I know that most of our in-house folks have their spreadsheets and, try to follow up on stuff. What would you say is the right timeline for following up? Is it every 30 days, or does it take longer than that? What do you really mean with diligence? What does that timeline look like?
It's more of some people, when they get their title insurance claim accepted, they just kind of put it on the back burner and think that, oh, well, I'll just get notified when it's resolved. Then all of a sudden a year goes by, 2 years goes by, it's not done. Every 60 days is probably fine just to do a tickler on it, but it's just to make sure they're actually doing something, and they're doing something that's in your interest. There was a recent case in the last 2 years against Fidelity out of Hawaii, and basically the title insurer knew that there was really no merit to the defense, but they didn't want to pay, and so they just kept delaying the litigation, doing more things, and going up on appeal. And Fidelity lost, and they took it up to the Supreme Court of Hawaii, or vice versa, but either way there was a large judgment against Fidelity for taking unreasonable actions to delay as opposed to resolve. So you just want to make sure they're doing stuff and you're involved, is my primary point of being diligent.
Monica, this is Susan. We had one question. It's actually for Michael. Michael, if you could respond to this. It was a question. Would law firms be required to obtain license and certification to collect debts if McNair wins?
That's a good question. I don't think there's a definitive answer to that. Being licensed to practice law gives you a lot of rights and privileges within the state to do a lot of things, but and including collecting debts. So I don't think any additional license would be required. But given the fact that this is kind of an incursion into the normal rules governing the practice of law, it's not really clear how state licensing authorities would reply. I think the existing Bar Association membership is probably going to be broad enough, but it's not certain.
Okay, thank you. If you look in the chat dialogue, we also have a couple of inquiries there. Comment, great presentation, Jason. Can you elaborate more on the suggestion you made providing title insurer with the entire loan file prior to closing? Will they accept it? Do you have recommendations on how to handle the consumer privacy issues associated with providing the file?
I'll do the consumer privacy issue first. I would just recommend that you have a new form prepared which authorizes you to provide any consumer information to the title insurer and make that part of your standard forms. That way you just know it's there, and then that would justify it. How do I provide it? Some technical savvy clients of mine will put a hyperlink in their instructions and they'll email them to title so that the title insurer can just click the link and have it, or send a CD. Some title insurers do squawk about it because they've come to know the reason why my clients have been sending it to them, which is to avoid Exclusion 3A and Exclusion 3B. But if you send it, you've at least complied with your disclosure obligation, even if they've rejected it. And I have a form provision that I recommend everyone add to their escrow instructions in some fashion. If anyone wants to email me, I'd be happy to send you that provision.
Great. And one other question. Oh, go ahead. I'm sorry.
I was just going to share that Jason's email is jgoldstein@buchalter.com. Go ahead, Susan.
Great. Jason, how many would you estimate claims have you handled where an independent escrow handled the transaction and where the independent escrow company was found negligent?
Most of the time, my clients use escrow agents that are affiliated with the title insurer, and then it's normally all resolved together. I don't think I'm not necessarily saying independent escrow agents are worse than underwritten title company escrow agents. The point is that they don't have any assets generally, and that's the reason for my recommendation not to use them. It's more of a concern. A few times I've seen them found negligent, or they go bankrupt, or they don't have assets, and then my client doesn't want to waste the time or money to sue them, and they just take it as a loss. It's more of just a tip on avoiding a future problem, is to make sure that your escrow agent has substantial assets if an issue arises.
Great, thank you. Any additional questions, Susan?
I am not seeing any additional questions.
Okay, well, I know that we are just a few minutes over. Did you have an additional slide you wanted to share on an upcoming webinar?
Yes. We have, thank you all for joining us today. We don't have a webinar in August. That's one of the months that we take off, but we will resume a regular schedule in September. Our topic will be advertising and social media compliance. Our speakers will be John Jaffe with Mayor Brown and Pamela Flexer at Loan Pal. So great information to be shared on advertising and social media compliance in September. Thank you all for joining us, and have a great rest of the day.